Bismillahirrahmanirrahim. Dear fellows, today I deliver lecture number 12 on Companies Act 2017. In the prior lecture, I discussed the matter pertains to the transference of the shares. So, in this lecture, we discuss the process regarding the allotment of the shares. Section 67 of the Companies Act 2017 deals with all the processing as laid down for the transference of the shares. So it is not incorrect to state that the mechanized way is provided under this provision. So what is Section 67? The starting of the Section 67 provides application for and allotment of the shares and debentures. So for seeking the shares and debentures, first of all the application need to be given in a way as prescribed by the Commission, and such application shall not be of the value less than the Commission nominate, and such nomination regarding the value need to be passed by the Commission from time to time, either generally or specifically. So in subsection 1 of section 67 we discuss that application need to be given for the allotment of shares and the debentures. So what are the guidelines rendered by the Commission for the application? For this purpose, we need to look into the wires of section 20, subsection 2 of section 67. It provides that the Commission may specify the form of an application for the subscription of the shares and debentures, and such application need to contain the declaration or the verification as it may in the public interest deem necessary. So the main content of that application is the declaration, verification or the undertaking kind of thing from the applicant. So such declaration provides that the application should have a restrictive role to the extent of the persons in regard of which application is given. So subsection 3 provides that the application, that all certificates, statements and declarations made by the applicant shall be binding upon him. So if the statement is given at any point of time for the debentures or the shares, then it should have a binding nature. And further, subsection 4 provides that the application given for the allotment of the shares and debentures shall be irrevocable in nature. So once application is given, the stance is drawn before the Commission, then it can't be reverted at any cost. And furthermore, penal provisions are also provided in this regard under subsection 5. It categorically provides that whoever contravenes the provisions of subsection 1 or subsection 2 or makes any incorrect statement, declaration or verification in the application for the allotment of shares shall be liable to the penalty of level 2 on the standard scale. So it is condition precedent that if any wrong thing is committed, then it shall be penalized under this section. So nothing can be taken for grantedly at any cost under the wires of section 67 of the Companies Act 2017. So dear fellows, the sensitivity of this section 67 need to be understood because it creates the penal hierarchy in case of its violation. I hope that you learned the process as required to be followed for the allotment of the shares, and keep in touch with me for further lectures. Thank you very much. Allah Hafiz.